Okay. Hello, everyone. I'm your Chief Librarian here at Alexandria RPG, and going to talk about something that's on everybody's mind. Was the leak of what could possibly be the OGL 1.1. I have some notes over here, so if I look off camera, it's because of that. First, a lot of people are going crazy over this, kind of rightfully so. But I also think this might be Wizards of the Coast kind of testing the water. They're going to put out this thing that's like really crazy over the top, and then rein it in about 60%. Keep things like take royalties down to 10%, instead of going, hey, we'll put it out at 5%. Oh man, we could have done 10. Oh, but anyways, so everyone's talking about this leak of the OGL 1.1. If you remember, a few months, it was about a year ago, maybe. I don't remember exactly how long ago. Everybody went nuts when Cortex released their license that said that they were going to own the works of the creators as well, and they rightfully so. Cooler heads prevailed. They reined themselves in. They pulled it back and said, "Okay, we're not going to do that," and we got a reasonable license from them. So, want to put that out. Other companies have done not quite this much, but have put out really bad license agreements as well. So, one thing some people don't understand with this OGL. So, I'm not a lawyer. I have been, over the last couple of years, doing a lot of research on copyright law with games. I've been talking with a lot of copyright lawyers. There's stuff that we want to do within the library. So do not take this as legal advice. This is my opinion based upon research, reading through the documents, and the many hours I have spoken with copyright attorneys over the last 4 years plus. So, let me give a little historical kind of background on why the OGL exists. So, we all know D&D. TSR was the company that D&D came out underneath 1974. And in the 70s and 80s, TSR was owned by Gary Gygax and the Bloom brothers. Not really important, but in the 80s, they were gamers putting out some cool product, but they weren't business people. They brought somebody in that was great with books and everything, and she really helped them clean everything up. Gary Gygax even offered to, or tried to give her like 10% of the company, and for some reason or another didn't. Well, behind his back, she ends up buying out the Blum brothers and doing a hostile takeover. And then, so in like 87 or something like that, I forget the exact year, she who shall not be named, Lorena Williams, ends up taking over TSR. And if you don't understand the who shall not be named reference, a lot of people held very ill will to her for a very long time. She was the wrong person to head the company, but should have been part of the company to help keep them solvent. Because I think with somebody like Gary Gygax or the Blum brothers in charge, and her making them try to make better business decisions while making good gaming decisions, would have been a great combo. But gamers left. You have Bean Counter in charge and making lots of bad decisions. A lot of those bad decisions were constantly going after anybody that was trying to do anything related to D&D. It was them being really protective of their IP, and I don't blame them for that. Games Workshop does it. They get beat up over it all the time, but they don't want third-party stories of Ragnar Blackmane, having a girlfriend and 35 illegitimate half Space Marine children running around the galaxy. Trust me, I've actually seen somebody that was writing that bad fanfic, and I was like, oh. And it was badly written, too. So these companies try to really hard to keep control over their IP. But the problem with a lot of the lawsuits in the late 80s and through the 90s were people that were really trying to produce stuff that would have made D&D a better system. Would have been, awesome add-ons. Hey, we're not using your written IP, we're just using your mechanics. So they just went after everybody. And most people either didn't have the money to get a lawyer to fight it, or they didn't they didn't want TSR to look like the bad guy. Like, oh, if I go to court, TSR will look like the bad guy. They backed off, thinking be better for the industry. Well, 1987-ish, Peter Atkins from Wizards Coast, I believe, wanted to merge with TSR, something like that. And somebody goes up there, checks out the TSR facilities, and just calls them and says, oh my God, you need to buy them, otherwise they're going to be bankrupt in weeks. And they really were. They were so close to bankruptcy. So Peter Atkinson and Wizards Coast purchased TSR, saved D&D. Truly saved D&D, because if they wouldn't have stepped in, they would have, D&D would have gone bankrupt and honestly would have disappeared. Now that also kind of put WotC, Wizards Coast, on shaky ground, because they spent a lot of money buying the owner of the #1 role-playing game. But it also put the industry in a really bad place, because you think every distributor, every bookstore, tons of comic stores, people that weren't as invested in role-playing games, because you didn't really have game stores back then. You went to a bookstore, hobby store, a comic book store to get your role-playing games for the most part. Or you direct ordered them or ordered them through a catalog. And all of a sudden, all these people that really don't know much about the industry just hear that the company that put out the largest role-playing game was basically bankrupt and bought by a company that makes cards and board games. All of a sudden, industry's toast. So WotC's kind of in a bad place. Hasbro buys WotC. 2000, the guy that actually went up to TSR for Peter Atkinson is the one that sat down and helped put together the original OGL, the OGL 1.0. So the entire concept behind the original OGL was less of a license, more of an agreement that, hey, help us rebuild Dungeons and Dragons with this 3rd edition, and we won't sue you. So, honestly, it was the main reason the industry was able to heal the way it did, because only a handful of companies like R. Telsorian, Chaosium, Palladium, Steve Jackson Games, stuff like that, and game companies that survived that didn't survive later were like White Wolf. So I mean, it was hard. It was a really hard time. So the OGL really did help the industry reignite, and we've had 22 years of basically continual growth within the industry. Even in 2008, when everything kind of slid backwards in the world, most companies did okay and were continue to sell well. But that OGL was really needed, because after a decade plus of people being sued by the largest role-playing game maker, they needed something to go, okay, let's, what do we do? And they put this out so that they could get the community and all the fans and all the small companies on board to really reignite the industry. And they did. It worked. So we are where we are now a lot because of that agreement through the OGL. So with that little bit of background and kind of why it came to be, let's get into kind of looking over some of this 1.1 leak. So first, people have a lot of confusion. You've got the 1.0 and the 1.0A, and everybody's like, oh, well, it says in perpetuity. Okay, that's correct. Basically, after talking with some copyright attorneys, they said, if you have something that's on the market right now, you will remain under either 1.0 or 1.0A in perpetuity. WotC cannot take that away. But in 1.0 and 1.0A, it does say you can choose whatever version of this OGL that's authorized. And the wording that currently sits in that 1.1 says this is the only authorized version. All previous editions of the OGL are no longer authorized. So that makes them, from the day, if this goes forward, from the day that's published, no one can use OGL 1.0 and 1A on a new product. So there's a lot of people going, oh, they can't go back and destroy an old product. That's correct. They cannot go back and revoke an old license agreement like that. There may be other ways that they can do it. The older OGL is much harder to get rid of in its provisions. So, wanted to get that out of the way because there was a lot of people that have been very wrong in that. So, here's some red flags for me in reading through the 9,000. It's 10 times bigger because the original was 900 words. A lot of companies just printed it in the back of their books back in the day. So, as I was going through, the blatantly racist, sexist, homophobic, transphobic, bigoted, or otherwise discriminatory. That line in there that said, they could revoke anything, revoke this license based on all that. Looks very cut and dry, but it's very vague, especially that otherwise discriminatory. Because something that is okay today, 6 months from now, or another person sitting in that seat reviewing a product could be like, no, I find that discriminatory, or I find that sexist, or because, look at the change that WotC is doing between using race and species, which honestly, the words don't really matter other than one gets some people's heckles up. In the grand scheme of things, they don't really mean anything different when you look at scientific taxonomy and stuff, which is what people are trying to invoke. But anyways, whoever's sitting in the seat reviewing something can change their mind or look at it through a different lens and go, nope, don't like that. That is now, sexist or otherwise discriminatory, and yank the license. Getting into a contract with very vague terminology and wording like that can be very bad. So that was my first red flag. Well, not necessarily my first one. I had a bunch of red flags. I kind of took notes and then kind of reorder them in a different way. Because that one also leads into my second, way bigger red flag. Can be canceled with any reason, for any reasons within 30 days notice. Why would anyone agree to a licensing deal like that? I've got this great idea. It's awesome. I'm going through, get everything approved. I'm OGL 1.0 certified, and I let everybody know, okay, my book releases on March 29th, and February 1st comes around, hey, I've got all the books in hand. We're going to start shipping out here shortly. And then WotC gives a call and says, hey, by the way, your OGL license has been pulled. Here's your 30 days notice. The crazy part about all that is you read in there, it says you must destroy all physical copies. So I've spent all this money getting all these game books printed, developed. I've not even counting my time to make the game or the art or whatever. Getting the books to the point where I have them in hand and being told that I now have to destroy those and I can't sell them. That is insane. Imagine if they did that to Paizo. So Paizo didn't do PaizoCon the year leading up to Starfinder, and a lot of people were like, oh, why? Paizo doesn't have really big margins. They sell a lot, but it's expensive making books. A lot of people don't realize that, and that's part of the reason why Wizards of the Coast wants to get out of making books, because they're extremely expensive to produce. They were, prior to 5th edition, the largest printer in the United States. With 5th edition, they shut down all their book printing and they shipped it all overseas. That's why, if many of you remember, a lot of stores got books that were the insides were upside down because they didn't have the quality control that they did when they were printing the books themselves. They just sent a small team over there to do quality control, and they were just cranking out the books faster than the poor team of a couple people could actually look. And you just, when you're cranking things out so fast, there's no way you're going to get proper quality control. But producing books is expensive. WotC has wanted to get out of producing books for ages because your margins are so slim. And I mean, from what I understand, the D&D 5e books are being sold on Amazon for less than their cost. And that's insane to me. Well, I mean, they're trying to get people into the game. I get that. But, you know, whatever. Now, think of the situation where Paizo spent a ton of money. They cut every corner they could in their day-to-day operations to make sure that they could get all of the copies of Starfinder printed that they could. They launch it. It actually does well, and Starfinder's been still selling fairly well. We know lots of people within the gaming community that's playing, and they have a fairly active player base, and they spend a decent amount of money. But if Starfinder would have failed, Paizo would have probably been gone. Now imagine that same thing under OGL 1.1. Paizo scrimps and saves, puts every penny they can, and, you know, betting the company on this new game. And then WotC goes, oh, by the way, your new Starfinder game comes out in 31 days. Because you know that they've got the books and they're shipping them out to everybody, before then. And they go, you no longer have a 1.1 license, and you now have to destroy all those books that you just paid millions of dollars for. Paizo had been gone. So I'm sure that Paizo and some of these other companies, because they haven't spoke up, are probably either waiting to see how this actually plays out, or they're already in talks with WotC for an updated, better deal than what OGL 1.1 is. They're going to have special OGL 1.1 commercial, whatever. So the ability to cancel for any reason within 30 days notice, no matter what's in the book, it could be the greatest thing ever, and they could all love it and there's no issues with any of the content, and it's like, yeah, we're just going to cancel it. It's insane. Why would anybody go into a contract like that, or license agreement? So within that, now we're on to number 3. They own the rights, irrevocable, in perpetuity, of your content. You can make money off of it, but at any time, they can make money off of it and not pay you for it. This, I have no clue how this got through with lawyers, especially after what happened with the Cortex license. It's the same thing, but even worse. So the industry's gone through this particular one before. This one's really bad. So the industry as a whole has talked about this particular one. Again, we talked about it when Cortex did it. And honestly, I think that one was more of a lawyer going, this sounds great. And somebody didn't follow up on what everything said. And, they were like, oh, geez. So I'm not going to go over that one any further. We all understand how insane that one is. Hey, I made this cool new thing, but I'm using your OGL. We're going to print your book. Haha. And you get nothing out of it. So, number 4, virtual tabletops and other digital content. Everybody's worried about Roll20, or about all the different people that play online. That's not where I'm looking. I'm looking right now at all the virtual tabletops. So, like, Wizards of the Coast bought the D&D Beyond. So it's not a virtual tabletop. All it is digital character sheets, basically. But they are working on their in one D&D system, their own weird. If you've seen the videos of it, it's a weird 3D virtual tabletop that, to me, takes a lot of the theater of the mind out. I'm not a big fan of doing. I mean, I like 3D terrain and stuff when I'm sitting at the table, but that's a very big difference than making it look like a kind of a wonky MMORPG that I'm kind of part of. But companies like One Bookshelf. That One Bookshelf owns what is it? DM's Guild, Drive Through RPG, and Roll20. All three of those have tons of product. I mean, Roll20 has 10 to 12 million people on their platform. And what D&D Beyond, when they were bought, they reported around 10 million. WotC's saying that they're like 15 or 16 million or whatever it is now, and possibly so, because once they were bought by WotC, a lot of people finally heard about it, like, oh, cool. But with Roll20, they've got something like 12 million active users, and roughly half of them play 5e. Now, the upside of that means the other half don't play 5e. That's a ton of that's 6 million people playing other games, which is awesome. But what could happen with this license and all of the content that they support already that uses the OGL? That's where I'm like, ooh, because you've got companies like Roll20, Foundry, Fantasy Grounds, Owlbear Rodeo, Tabletop Simulator, and there's just a ton of other virtual tabletops out there that probably going to get really hosed. And this is when I talk about stuff later, this is the one area that I don't know how it's going to play out. And I think it's the one area that no one's really talked about. They're like, oh, what about Critical Role? I was like, Critical Role, they're fine. And they have the money to, buy some lawyers to fight that. But I don't think the online play, people recording themselves and sharing them playing, I don't think that is going to be anything that WotC's ever going to be able to take on legally. But the virtual tabletops is something I think they will, and it could hurt the industry as a whole. So a lot of them are probably going to have generic rules and no books available anymore, which could really hurt. Number 5, royalties. So people think the $750,000 it's only going to hit a small amount of people, but it's a 25% royalty. I just talked about how rough it was for Paizo to get all the funding and everything together so that they could produce Starfinder. For years, I knew plenty of people throughout the company within Games Workshop, and whenever they actually were getting ready to release a new miniature line, they took out large loans to pay for all the molds and everything and the initial runs. And it was hey, if this sells well, they'll pay back the loan within. They would pay them. And you actually, it's not good to pay back loans really fast. It's funny, but so they would take 6 months or a year to pay back that loan, but they would initially, within that first 4 or 5 months, make enough to more than cover that entire loan. And then after that, it was kind of just, hey, we're now actually making profit off of this. Similar things happen within the game industry. I mean, if you've ever worked on a crowdfunding, and people are like, oh, well, if you make $750,001, you're only charged 25% on that one. Well, what if you've hit 1.5 million? So you're charged 25% of $750,000 at that point. That is a massive chunk out of a Kickstarter. And that's the other weird thing is the royalties on Kickstarter are only 20%, where they're 25% if you publish yourself or if you use another platform. So they're punishing BackerKit for starting to do their own crowdfunding. They're punishing GameFound for being a game-focused crowdfunding source. They're punishing Indiegogo. Anything else out there that does that. And it's like, hey, another 5% off the top if you don't go Kickstarter. Very strange to me. And it sounds like they've made deals with Kickstarter. I guarantee they've made deals with Kickstarter because there's a 5% difference. So a 25% royalty is insane. I've never seen a 25% royalty on any product, on anything really outside of the music industry. A 20% royalty would bankrupt most companies. They would just say, well, they've got to charge way more, or they go out of business. So I don't want to beat a dead horse. Not everyone, everyone not publishing. What am I trying to say? I do really think that a lot of the larger publishers are working on things with WotC for their own agreements. This is the one for all others. So a million people have made videos covering a lot of this stuff. A lot of people have kind of gotten things wrong. A lot of people have gotten a lot of things right. There's a lot of people that are confused about, they think that this will negate any book that was made under the 1.1 and 1.A. It's like, no, if those are already in production, they've already been published, you have that license in perpetuity. WotC can't revoke that. Just moving forward, you would have to use 1.1. Now, here's where I get into some of the conversations I've had with some of the lawyers over the last couple of years, because we've been looking into trying to resurrect some old games. And we get game designers all the time that come through looking at books and trying to find cool rules to adapt to their game. Because you can't copyright game mechanics. And this was not a well-known thing. So in 2016, we finally got a court case out of Texas that covers the a game. So it was Da Vinci. They're actually a game company out of Italy. They make a game called Bang. Actually, Bang! Because it has an exclamation point at the end. So Bang is a card-based social deduction game. Social deduction games have been around for ages. I remember, on forums and BBS's, bulletin board systems back in the day, a game called Mafia. Rules were just kind of sent around. Like I played Mafia and various versions of Werewolf back in the 90s before they were printed by any company. So the basic concept of Bang isn't new. But this company Zico, they're a US-based company. They printed in the U.S. a game for a company out of China. It was the Legends of the Three Kingdoms. It was Bang. All the rules, the mechanics, everything. They just reskinned everything and renamed everything. So they go to court. Both companies agree the underlying games are identical. All of the mechanics are identical. And, people are like, well, they stole the game. And it's like, so the judge in the ruling saying copyright doesn't cover game rules, procedures, or winning conditions. So you can take anybody's rule set and adapt it to your thing. And one of the justifications they used was a Supreme Court case in 1879. It's in here somewhere. Baker versus Selden. And it was about bookkeeping systems. So I believe it was Baker made one of the two had written several books about bookkeeping and had a system and procedures. And then the other one came along. So I think it was Baker that wrote the books, and then Selden came along and like made a product to sell to people using the other party's system. And the case came down to the systems and mechanics cannot be copyright protected. Language and art can. So, if we're looking at this, Wizards of the Coast, they can't sue you for using their mechanics based upon the Da Vinci versus Zico and the Baker versus Selden. So, and the Baker versus Selden had been sitting out there since 1879. Just nobody had really done any fruitful lawsuit within the gaming industry until this 2016 case that references this 1879 case. So, as long as you aren't using anything language-wise that's copy protected under any copyrights that Wizards of the Coast use, like Wizards of the Coast, Dungeons and Dragons, let's see, Beholder, Mind Flayers. So all of those things, they can sue you for. They can sue you for using their art. But with these cases, we now have case law to say, great, I'm just going to use all these rules and I'm going to make my own game. I don't like what you're doing, or I do like what you're doing, but I want to do it with a twist. I want to call things races. I want to have, dwarfs with, limits and negatives. I want to have elves with limits and negatives. I want to have, limits and negatives on humans. I want to do, half bipedal squids. I don't know. Whatever you want to throw into your game. So with these cases, you can use all the same dice. You can use all the same rules, concepts, and mechanics. You just can't use their language that they have actually copyrights on. And you can look up what they have copyrights on, and you can't use their art. So I think the industry as a whole needs to get together and go, hey, we have this legal precedent, and we're going to keep doing what we're doing because we've created a fan base and we're just going to keep going. Now, some people are like, where does this stem from? So I joked earlier about the former CEO of TSR, Lorena Williams, being called she who shall not be named. Because there were a lot of people very angry with her, like what happened with TSR. And again, I think she would have been great to be part of the company, but she was not who needed to lead the company. And the current head of Hasbro is the current CEO of Hasbro is the former CEO of Wizards of the Coast, because Wizards of the Coast is a subsidiary of Hasbro, and he's a former Microsoft employee. Giant end-user license agreements and stuff like that. The current CEO of Wizards of the Coast is a former lead. I forget what her exact position was, but she worked over like in the Xbox division of Microsoft. So, microtransactions, figuring out how to monetize every little thing with a player. And they came out and said, we need to monetize this better. There's not much you can monetize better with on role-playing games. They were like, 20% of our player base is doing 80% of the purchasing. That sounds like your GMs are buying books and your players aren't. Welcome to role-playing games. It's been that way since 1974. That's never really going to change. And they've tried really hard, because if you look at most of the 5e books that WotC's been putting out, they're very player-centric, which is kind of a negative thing, because they're also complaining that they don't have enough GMs. Well, you've made your books not friendly for GMs. You made them friendly for players, trying to drive sales, but it's not working, because that's not how the industry goes. So make your books more DM centric, with some cool, like, and just add cool stuff in there, cool content and art and stories, the players will buy them. You will get some spillover from players buying the cool stuff. But your GMs are going to buy the books if they are GM centric, giving the GM great advice and building out the world in a better way. And some companies do that well, and some don't. Now, the last of the trifecta here in this, the current lead on Dungeons and Dragons just came over from Microsoft, but he was, I believe, the chief of operations on the 365 team. The team that took Microsoft Office, made it a monthly subscription, have basically microtransactions and cloud-based everything, so you can use it from wherever. Oh yeah, this is awesome. My wife joked that probably the only worst company would have been Adobe to be leading this. At least they would have been, from a creative background versus, Office software. And the new lead of D&D said he's grown up as a huge D&D player, for years, and I hope so. But we can see, and I said as soon as they announced the new CEO of WotC, I saw where she was coming from. I was like, hey, we need to watch out. They're going to try to digitize everything, and we're going to get microtransaction. Everybody said I was crazy. And then when they announced the new head of D&D, I said, hey, watch out. This is what's coming. Everybody said I was crazy. Hey, the crazy guy has been trying to tell you for a couple years now, this is the direction everything's heading. So, jokingly, new CEO of Wizards of the Coast is she who shall not be named Junior. It's not that I want to get that trending. I just think if we do get that trending, maybe they'll realize that, oh, I'm going down the wrong path. If they know the history of the company. So, if the copyright attorneys I've been talking with and these case laws are correct, the OGL is not needed. We can, as a community, as an industry, can make the games we want to make using the rules we want to use. We just have to make sure we don't use copyrighted material. So don't put beholders in your books. Don't use TSR or WotC art. WotC got into trouble early on because they had the physical rights to Knights of the Dinner Table, but not the digital rights. And then they produced all the Dragon magazines on CDs. Well, they ended up getting sued over that, rightfully so, because they did not have the rights to produce that. And that's how we ended up getting Hackmaster, based on second edition. So, if you want to use the OGL logos and everything, and you're comfortable with what comes out with the OGL 1.1 when it is printed, go for it. But when it comes in the end, the OGL is no longer needed. The industry is not in a place right now where it was in 1999, because when everything collapsed in those last couple years of the 90s, it was amazing the companies that survived that did. And some people were like, oh, well, this is what happens when you bandwagon. No, you have companies that have been making amazing products that have made the industry what it is. Wizards of the Coast would not be as big as it is if it was not for the OGL. The industry would not be around if not for the OGL. D&D 3 and 3.5, well, probably never gotten a 3.5. We would have gotten some people that picked it up and said, meh, whatever. And, I've got a ton of second ed stuff, and just kept playing that. And then you would have had, a handful of very small companies eking out a living. People like, I remember when role-playing games were a thing. So, OGL was a good thing for 20 years. And it's no longer needed. We now have case law on our side. Please go look up the cases. I will link them below. It's, let me read them again. Baker versus Selden, Supreme Court case, 1879. that's about the bookkeeping systems. And then the gaming one is Da Vinci versus Zico, Ziko, out of Texas in 2016, and it cites the Baker versus Selden as part of why they reached that decision. So, and they said in there, covers games, rules, procedures, and winning conditions, which is all the mechanics of a game. So, WotC can't go after you for using those if this case law reads as myself and the lawyers the copyright attorneys I was speaking with say it does. So, with that, I really hope that WotC changes streams, realizes that they're kind of doing the industry wrong, and changes everything up. But I don't know. I really think WotC is trying to push as many people out so that they can get totally out of the publishing game and do everything via an app or a program, and then charge you monthly for it. And charge you, microtransactions. Ooh, you want a new costume for your Ranger Mini? Here you go. Only $5.99 to go get your woodland full plate ironwood armor. So I hope everyone's doing well, and if you want to find out more information about the library, you can check us out at alexandriarpg.com. We are a 501c3. We're a nonprofit. We travel around to events. We talk to people about the history of role-playing games, and I've been trying to figure out how to save more and more games. We have a few thousand. We're over 6,000 books in the library right now, and we're constantly getting new books from awesome game developers. We talk to game developers of all kinds of backgrounds that are making some awesome stuff. And if you're frustrated with this, there's a lot of options out there. And you can find a lot of awesome games. Look up Free League. Free League is doing a tons of stuff. Renegade Games, they helped get us to, what is it called? Gen Con this year, and donated a ton of books. They're doing G.I. Joe, Transformers, and Power Rangers. Things that we've never thought we'd see, and things that we adapted into RPGs back in the day. Look up Monty Cook. Monty Cook did a bunch of work with us at PAX Unplugged this year. Look up like Artel Saurian, Palladium, Chaosium, companies that made it through the years. Steve Jackson Games is still making GURPS and making awesome stuff for that. There's a lot of games out there. You may have to learn a new rule set, but go for it. There's so many amazing games out there to learn. I can grab probably 10 games right in front of me that aren't 5e based. Modifius making Star Trek, Free League making Alien and Blade Runner. Oh god, well, making Vaesen. So there's games coming out of Japan. Tons of awesome RPGs starting to come out of Japan that are being now printed in English. They're a little harder to locate, but if you look around, you can find them. But anyways, this is a crazy thing happening. I really hope WotC changes path, but there are options, and I really do believe that case law is on the side of the industry and not on the side of WotC now. Guarantee that there's some lawyers that are going to be all over this and be willing to fight WotC right out the gates. So everyone have a good night, and the library is now closed.